hello. Thank you, guys. I'm very honored to speak with you today. Today, we have found some recent footage from an attorney who is involved with a lot of the doctors that we know fighting the COVID fight. And they're giving the tutorials by the judges, and the judges are following my protocol perfectly. They're doing a great job. The fiction judges are doing it to the T, dismissing their cases under false and misleading statements because none of these people are bringing any, and they're even saying this, the attorneys are they're saying, the judge is saying we're not using any facts, so they're following the protocol. They're in the District of Columbia, so I have them very trained there. The judges trained in the form of the United States very well, and the judges are doing it perfect under no law or fact shall be tried in court under Federal Rule of Civil Procedure 44.1, he court not jury. And now you guys are going to get a first-hand tutorial on the attorneys and why they can't figure out what about the judge is talking about them using an opinions, using false and misleading statements, using the program perfectly. They are completely trained. I did a good job training the judicial systems of the world. And these attorneys, as smart as they are, can't figure out why the courts won't say they're not using any facts. So it's pretty fascinating to watch. The protocols actually be followed by the fiction courts because they're supposed to follow the boss's rules, and they have done it perfectly. So it's kind of exciting for me to watch the piled high and deeper attorneys having a hard time with not being able to figure out what the hell's going on. So I did a good job at training the judicial systems, and the judges, of course, doing a good job because they are slaves working for the postal construct, and they are doing a great job following no law or fact shall be tried in court. So with that, here we go.
WAPO case.
Okay, so Malone was suing Washington Post. He's suing a couple of other doctors simultaneously as well for defamation. The standard stuff. I hadn't been following the suit, but I mean, you'll tell me, Robert. This judge sounds like the judge sounds wildly partisan. I don't know who the judge is or what the history is, but the judge didn't slap Malone with. Pun intended, because it's an anti-slap argument raised, with the legal fees for the Washington Post, but said that if he continues with his defamation lawsuits, someone somewhere down the line might consider his lawsuits to be frivolous and worthy of being imposed, legal fees for the other party. Sued the Washington Post, and the judge basically says this is they're exercising First Amendment rights on an issue of national importance, COVID, et cetera, et cetera. Therefore, slap provisions or the anti-slap provisions apply, and they tossed Malone's lawsuit. He has two other lawsuits that are currently pending against the doctors, although the judge did fault Malone, I think, for having gotten new counsel, or what was did I make a mistake on that? Either way, Robert, Washington Post is off the hook. What's your take, and is this just more of the same rules for thee but not for me?
Yeah, because, I mean, what the Washington Post said about him was that he made statements that were, quote, discredited, that he was, quote, spreading misinformation, that he, quote, repeated falsehoods, that he, quote, was not accurately representing the information, that he made unfounded claims, and maybe most significantly, they accused him of fraudulent conduct. Historically, that is actionable as libel because you're implying that there's a factual statement that he has made that is untrue. So how did the judge evade that? The judge decided that all that was just hyperbole, rhetoric, opinions that didn't apply any fact at all.
A perfect case where the judge is following the protocols of judgeship to the T under he court not jury under Federal Rules Civil Procedure 44.1. And he's articulating that you can't use opinions and there are no facts in the case. And because Malone and their complaints are all written in fiction, which are frivolous. And they can't figure out why the judge is overruling, and they can't get a jury trial because there's no jury because they're in a foreign jurisdiction under he court not jury under Federal Rules Civil Procedure 44.1. But because these attorneys are only attorneys and they only got PhDs, which is not really in the in club, and the federal judges aren't really in the in club too, because I got them very compartmentalized too, but they're high enough to know and have watched the course on if no one's talking, everyone's walking, and so they get them to talk into subject matter, and then they pop the gauntlet on them under he court not jury. So it's kind of exciting for me to watch the judicial system do the correct thing staying in fiction under he court not jury and not allowing their fiction lawsuits through. So it's very, very fun to watch for me. So here we go. We'll start breaking it down.
Any fact at all, which quite frankly is a ludicrous interpretation of the complaint. What he's doing is he's substituting himself for the jury, which he's not supposed to do.
He court is you're entering the judge's court under the yellow French flag, and he's setting the terms of his rules because he is moving the court into admiralty, and he is the captain as the shipping commissioner of what he allows through the port. So he's doing a good job. The fiction judge is doing it perfectly. The thing is the attorneys, unfortunately, and the people filing the lawsuits are writing in fiction and saying nothing, and the judges are going, well, there's nothing here. There's no facts. And you're only using opinions in a court. Remember, no law or fact shall be tried in court, which means that you can't put facts on trial, only the condition of mind. And the attorneys are not trained in putting the condition of thinking on trial because they're looking at subject matter and not the condition of thinking. So it's really cool to watch these attorneys get slaughtered. I'm really having a good time.
Because he kept talking about how he, quote, fairly read the complaint, fairly read the article.
There it is. There it is. So because we've studied Federal Rule Civil Procedure 44.1 and we comprehend what he court not jury is, the judge is right on point. And because they're in usury with his jurisdiction through their fraudulent file stamps, the judge is merely acting in admiralty as the master of the case, making sure that they don't get any remedy. And he has to stay in compliance with coloring of the law, in compliance with him, the judge, being in violation of Title 18-242, coloring. So now he's going to color the fact that the claimants, or the plaintiffs in this case, the attorneys bringing the lawsuit against whoever they're bringing against, don't have any facts because they're using opinions, in their opinion, using opinions upon coloring. So it's really, I hope this kind of opens your eyes up to what's happening here. Is the judicial systems are correct and not allowing fiction through the port.